Hey everyone, today I'm going to be going over Disney's state court motion to dismiss that case. Then I'm going to go over the attorneys in the case, who they are. I'm going to compare them to what celebrities should play them if they're ever turned into a movie. And then I'm going to go over DeSantis's motion in the federal case, asking the judge to recuse himself. So, let's get into it. You are listening to Follow That Case, a legal podcast by award-winning attorney Leland Fox, aka Fickle Father, aka me. Coming at you literally from my bedroom closet, I'm bringing joy into your life like only civil lawsuits can. So subscribe, and let's get civil. Okay, so I now have in front of me here the Disney's motion to dismiss, which was filed May 16, 2023. This was filed in the state court. So this is a motion to dismiss the board's lawsuit that they filed in state court against Disney. And so again, I've gone through and highlighted the main points here, but the first thing they're saying is that the court should dismiss plaintiff's amended complaint as moot, meaning it doesn't have any more issues that need to be resolved. And then they're saying in the alternative, so if we don't dismiss the case for being moot, the court should stay the case under the priority principle, which basically means, hey, we filed first, which was in federal court, and our case encompasses all these issues already. And so since we were first, that court gets it. And then here are all the citations. And I'm going to read through some of this introduction here, and then I'll read some of the legal arguments. And then I have some comments on some things that I'm thinking might be happening in the background or that they might be setting up for. So just over a year ago, Disney expressed a political view that Governor DeSantis did not like. And we've gone over that with Don't Say Gay law. In response, the governor unleashed a campaign of retaliation, weaponizing the power of the government to punish Disney for its protected speech. Faced with a newly hostile state administration, Disney aimed to protect its planned investments in Central California, including thousands of new jobs and billions of dollars in capital over the next decade. They were going to spend $17 billion and bring 55,000 jobs to Florida was the plan. So they protected their investments in Central Florida by executing 2 development contracts with the local government body. And I'm going to come back to that later. But they say here, public notice appeared twice in a prominent Orlando newspaper, and there were 2 public hearings on the subject. Over no objection, the contracts were executed in early February. And last time we talked about in the district's lawsuit here in the state court, Florida State Court, the first reason they gave that Disney's contracts that they entered into with the board that were just referenced here, the first reason that the board said the contracts were void is for failure to follow notice requirements, specifically failing to mail notice prior to the first hearing to all affected property owners. And so I thought when I was first reading this that maybe Disney would mention that, and we did mail it, even though it wasn't in their complaint, but they didn't mention mailing, so I think maybe they didn't mail it for real. And yeah, so I think that's an interesting point there. A key component of the governor's retaliation campaign was to replace the elected board of Disney's local government entity with a hostile board, handpicked by the governor. And this is another thing that I talked about in the last time, or the last episode. We talked about how Governor DeSantis is saying we need to level the playing field so that Disney's has the same playing field as every other business. And my question was, well, do any of these other special districts that have a governor-appointed board, like now the Reedy Creek district has? Because if they don't, then it's not really equal footing. It's very different. But anyway, so Disney kind of touches on that here. They say none of the nearly 2,000 other special government districts in Florida underwent any similar state-mandated revision to its governance structure. So they're saying we're singled out here. And then they just kind of go on to tell the story we've already told twice now, which is that the board said that they were going to be voiding the contracts. And then they touch on here that so shortly after how Governor DeSantis said that he was going to take issue with that through legislature. So shortly thereafter, the governor followed through on his additional threat to take action against the contracts at the state level. 4 days after the board filed this case here in state court, the governor signed a legislation he had previewed, effectively voiding the contracts as a matter of state law by prohibiting the board from complying with the terms of the contracts. And here's the language from Senate Bill 1604. It says an independent special district is precluded from complying with the terms of any development agreement which is executed within 3 months of a law modifying the manner of selecting members of the governing body. And that's what happened. Is it used to be 1 acre vote. You get 1 vote per acre owned, and that was switched from vote to appointment by the governor. So, I mean, obviously they had some mechanism to make sure that the contracts can't be enforced, and this was it. The contracts were signed February 8th, 2023, and obviously you got February, March, April, so less than 2 months later, April 5, 2023 is when Senate Bill 1604 is passed. So, I mean, obviously that's going to be within 3 months. So this law is designed to prohibit the enforcement of those contracts, so it's obviously going to fit in their requirements. But that's what the law actually says. That's how DeSantis was able to legislate around the contracts. So now let's go back to what Disney was saying in their motion. That legislation renders plaintiff's complaint moot because it makes any order this court could issue in either party's favor legally irrelevant. If the court rejects the board's claims on their merits and agrees with Disney that the contracts complied with any procedural and substantive for some reason I have a hard time saying that word, requirements of state law, the board would still be prohibited from complying with them under the new statute. So if I'm saying that, it's like, hey, court, if you say the contracts are valid, then we don't get anywhere because the law says they can't be enforced anyway. For the same reason, even if the court found merit in the board's objection to the contracts, any order to that effect would be pointless because the contracts would already be void under the new state law. In short, any declaration about the contract's enforceability, voidness, or validity either way would be an advisory opinion with no real-world consequence. Trial courts in Florida are forbidden from issuing advisory opinions, and this case should be dismissed. So the way that I'm kind of taking this is Disney is saying, for the sake of the state court action, we have that law, which was House Bill 1604, which says that you can't enforce this contract anyway. So we're just going to say that law is valid. We're not going to fight that law. And so since that law says that these contracts are invalid, we don't need also a court to determine that they're invalid. We accept that this law was instituted. Contracts are invalid. Okay, that's fine. So there's no need for a court to issue an order on that. And it's a really good point, because what Disney is doing here is they're trying to get this case out of state court and put it all in federal court. And in federal court, what they're saying is, okay, yeah, even though we're not saying that 1604 is invalid for any reasons specific to 1604, what we're saying is 1604 was implemented unconstitutionally in violation of as a way of attacking us for speaking out against the Don't Say Gay law. And that's the reason why it was enacted. So even though it's a valid law right now, we're asking the federal court to invalidate it because it was implemented for retaliation against Disney, specifically for the First Amendment issues. So in this way, this is how Disney is trying to keep all of the case in Florida federal court where they filed. And interestingly enough, I read on the news that DeSantis has filed a motion for the federal court judge to recuse himself, saying that he's biased. And I'm going to talk a little bit about that later, but let me go down and just to touch on some more of these legal arguments here, just so we can cover all the details. The legal standard here is basically that it is the function of a judicial tribunal to decide actual controversies by a judgment which can be carried into effect, and not to give opinions on moot questions or to declare principles or rules of law which cannot affect the matter in issue. So again, it's just basically saying, hey, state court, however you come out on this, it doesn't matter, because we are already agreeing that the contracts are not enforceable based on a later enacted law. And then their alternative standard, which is basically saying, since we filed first in federal court and the federal court already encompasses all issues related to these contracts, that court should get the first bite at the apple, or the only bite at the apple, I guess. And they say here that it is an abuse of discretion. So if the judge decides it would be bad decision to refuse to stay a subsequently filed state court action in favor of a previously filed federal action which involves the same parties and the same or substantially similar issues. And in the argument, again, for the motion to dismiss for mootness, they say here the courts reserve their powers for cases involving actual controversies. Florida courts will dismiss a case if the issue raised have become moot, and an issue is moot when the controversy has been so fully resolved that a judicial determination can have no actual effect. And the important thing is that the state court case is limited only to the issues of, are the contracts enforceable? And effectively Disney is saying no, not necessarily because of what the board is saying, but because there's a law that says they're unenforceable. And so, yeah, I mean, I've already said that. And that's what, yeah, so they say, Disney says there is no order this court can issue that will affect the result, which is that this action is by a state board raising questions of validity of the contracts that are already void and unenforceable by unequivocal legislative. They say fiat. I don't know if I'd use that word because it's kind of in my mind a little bit of a has a negative connotation. I would have just said by legislative, act. So no matter how this court answers them, the board will not comply with the contracts because it legally cannot. Senate Bill 1604, I said House Bill, I guess it's Senate Bill, provides without qualification that the board is precluded from complying with the terms of the contract. And then notably here, they do note that there are some situations when a case can still go forward, even though there are issues with the question being moot. And that is the first one where questions raised are of great public importance. The second one is where the questions raised are likely to recur. Or the third one is where there are collateral legal consequences that affect the rights of a party that flow from the issue to be determined. And of course, they go on to say that none of these exceptions apply here. And I'm not going to get into that now because I want to see if the board is going to try and keep their case here in state court. And I'm assuming that they will. And I'm assuming it's going to be based on one of these exceptions, probably number one. And maybe I'll get into that too, because I am going to come back to this very first issue that I said I would come back to here in the introduction, because I think what Disney's doing here when they say that they're protecting their planned investments, I think they're giving us a little bit of a foreshadowing of what their theme and their argument is going to be. They're going to come in and say, because what I think, let me back up a little more. What I think DeSantis is going to do is they're going to say, hey, look at Disney coming in and trying to shove these last minute 11th hour contracts down Florida's throat is the exact type of thing that we need to institute this board for in the first place. That's why they need oversight. They're doing stuff like this. This isn't the only time. It's been going on forever, since 1967. They've pulled fast ones on us. This was supposed to be a residential community. That's what Epcot was supposed to be. That's what they told us. Now it's not. Never happened. It's like they're always just pulling the wool over our eyes. And that's I think the way that Florida will pitch it, and what Disney will say is like, well, we have a duty to our shareholders to protect our investments, to have a good business, and that's all we're doing with the contracts is protecting our investments. Governor DeSantis himself said that that's what corporations should be doing. And I'm going to play a clip of that. Okay, so I pulled up this video here. This is not specifically about Disney. This is a speech about ESGs, or ESGs. It's environmental and social governance of corporations. So it's woke politics. On the podium, of course, it says here, government of laws, not woke politics. And this was from a speech on February 13, 2023, just a few days after the passing of House Bill 9B. And that's the one that reconstituted the district, renaming it the Central Florida Tourism Oversight Board, and allowing Governor DeSantis to appoint his own board. But that's where we are in the chronology. This is his talk about woke politics in corporations, and I think it's important because it shows his line of thinking in doing all of these types of things.
The subject of today is tackling this issue of ESG. Now, they created this. These things just happen. I don't know where this stuff comes from, but these elites grab it and they really want to impose it on the rest of us. So it's called environment social governance, but basically I think what it's devolved into is a mechanism to inject political ideology into investment decisions, corporate governance, and really just the everyday economy. That is
woke
not
politics.
Ultimately something that is going to work out well for us here in Florida or in the United States of America. There's not a real groundswell for this from amongst the average citizen. It also...
I just want to add, when he says it won't work out well, that's something that Disney said that he told Bob Chapek when they first spoke on the phone about Disney wanting to get involved and say something about the Parental Rights and Education Act.
Violates the fiduciary duty that executives have to the shareholders of the publicly traded companies. You think about it, your pension money, your retirement money is likely invested in some of these funds, and those funds should be done to try to produce the best result for you using the available investment options. Well, what ESG says is, no, we're not going to do, even if it would do a better return, we're not going to allow you to invest in certain areas. You're not allowed to invest in oil and gas. You're not allowed to invest in disfavored areas. So they're constricting the ability of people to invest your money, and obviously that means you're going to not do as well as you otherwise could have.
So in other words, these companies are going to be pursuing these woke political agendas rather than pursuing the best returns for their shareholders.
So that is using your economic power to advance a political agenda. Now, this is something that I think is very serious because I think the policies are bad. I think having a politicized economy is not the way that you want to go. But it raises the idea of who governs our society. Our Constitution says we, the people, govern through elections and different houses of the legislature, executive, and you can kind of arrive at policy. People can evaluate that. They can choose other people in future elections. Well, what ESG does, and when you have major asset managers and these international folks and folks in these big Wall Street banks, they just want to do an end run around that. They don't want to have to worry about winning elections. In fact, a lot of the policies they pursue could never win favor with the American public. I mean, abolish ICE, saying that you should have an open border and that it's somehow wrong to be involved in immigration enforcement, that would never fly with the public. But that's what they're doing. And so this is this is a distortion of a government of, by, and for the people. They are not accountable to you. They are not accountable to us. And I think ultimately it does represent a threat, not just to a smooth and prosperous economy, smooth functioning, prosperous economy, but also our very freedom itself.
So I think these are going to be the competing themes. Disney's saying we're just trying to be a responsible corporation, doing things that are the best for our, I'll say, constituents / shareholders. DeSantis is going to be saying we're doing what our constituents want and what's best for the people of Florida by making sure that Disney can't be its own government because of things like this. So anyway, I think that's some foreshadowing, but I think this is a great move by Disney. When I read it, I was just like, oh man, these guys are good. But I also think that DeSantis's attorneys have been very good. And you know, the last time when in the news you saw that these contracts, Disney gets the last laugh or things of that nature, but then DeSantis overcomes that because I mean we're dealing with smart guys. They all happen to be guys. All the attorneys. Yeah. Anyway, we're dealing with smart attorneys, and I'm really interested to see how they're going to respond to this motion to dismiss. But when I read it, I think it's a good motion. I actually think Disney's right that if they're agreeing that the contracts are invalid by the law, then there's no point for the state court to also say, yeah, that's right, they are invalid. Unless those exceptions apply again, and I'll get those once I see how the board is going to respond, because I'm not doing that work. All right. Okay. So that covers the motion to dismiss, and I'll let you know when I see what happens next from here. Hey, from that last segment, I wanted to dig into who these attorneys are a little bit more, just because like I was going through it and I wasn't sure if they were all males. I thought they were, but I was wrong. There's 2 women attorneys that are involved in this case. So I am going to just take a minute to go over the attorneys for the different sides. We've got Disney, we've got the Reedy Creek, which is the Central Florida Tourism Oversight District now, their attorneys, and then we have DeSantis, which is the Attorney General's office. But I just want to introduce you to who these attorneys are. I don't know any of them personally, but let's go through this. So pull up the screen here. First one's, I'm going over Team Disney first. Their lead attorney is Daniel Petrocelli with the firm O'Melveny. They do entertainment law. Well, they're a large law firm, so they do all different sorts of law. But Daniel Petrocelli was named a legal legend by The Hollywood Reporter for his career work in the entertainment industry. He is the trial chair of that firm for all the civil trials, and he's also just the general vice chair for the entire firm for everything that they do. He went to law at Southwestern University, and if you remember the O.J. Simpson case, after the criminal trial, there was a civil trial for Ron Goldberg's father for a wrongful death action against O.J. Simpson. Daniel Petrocelli was the attorney for that case and won the civil case against O.J. Simpson. He was also involved, if you maybe have seen this in the news, in Superman IP litigation. During the COVID shutdown, Scarlett Johansson's Marvel movie, the Black Widow movie, was supposed to go to theaters but went to streaming instead, and that caused a big scene. But Petrocelli was the attorney for Disney dealing with Scarlett Johansson, and then he's currently litigating a Top Gun Maverick case. You've probably seen this one in the news too, where the creators of Top Gun are saying Disney never got the right, or who, maybe it wasn't Disney, but whichever studio that was didn't get clear the rights to doing a Top Gun sequel movie. So he's the attorney on that case. So he's been involved in a lot of cases you see on the news, and he's the lead attorney for Disney in this case against DeSantis. And then in his firm, oh, and I'm also going to go over here, if I were casting these people to be in a movie, who would I put as the actor? So for Daniel Petrocelli, I would put Steve Martin. Originally, I was going to say the guy that played the toy store owner in Home Alone 2, but he's passed away. So I've got Steve Martin. I think that's pretty good. Okay, the next attorney is Jonathan Hacker, also with O'Melveny. He is the appellate practice chair at that office. I went to law school at the University of Michigan. And so, if I'm thinking about how are they approaching this strategically, if they're kind of honing in on their roles at the offices, Petrocelli is overseeing the entire case for trial, setting it up, doing all the work, overseeing that. And Hacker would be looking at it maybe from the lens of the appeal and what issues do we think are going to cause problems, or what do we think might be an issue that's going to be taken up on appeal, those types of things. So his input would be helpful there. And then he has argued 6 cases at the U.S. Supreme Court, which is a lot. He's done a lot more briefing in the Supreme Court. And then they say he's done an appeal in every federal circuit court in the country. So a lot of appellate work for him. And if I were going to cast him in a movie, I think that I'm proud of this one. Jeff Daniels. I think he'd be a good fit. Has a similar look, in my opinion. Okay, next attorney is Steve Brody, and you're probably like, oh, I know exactly who you're going to say for the cast. I'm just going to give it away right now. It's why am I blanking on his name? Rick Moranis. Yeah, I think he looks so similar to Rick Moranis. Anyway, Steve Brody is the founder of the firm's Attorney General investigation practice. So if an attorney general from a state is investigating your company, that's what he helps manage for people. Law schools Washington and Lee. And if you've seen in the news, again, people taking on drug companies for the opioid crisis, he was one of those attorneys. He won a large trial against Johnson & Johnson. $425 million was awarded, or no, $465 million was awarded against Johnson & Johnson. But that decision was actually later overturned on appeal. So good work, Hacker. Just kidding. So Rick Moranis, I think, is the actor that would do a good job playing him just based on looks. Okay, now this attorney is not with O'Melveny. It's Alan Schoenfeld. I think I'm saying that right. With Wilmer Hale out of New York. He's a partner there. He went to law school at Yale. He's a former Supreme Court clerk. I think, I don't recall who he clerked for, but he's also big on doing cases for inmate treatment for inmates with gender dysphoria, not dysphoria. Sorry, can't read my own notes. And so he's also worked for Disney before and has gotten a case in Florida dismissed. I don't know the details on that. I just saw it on Wikipedia or something like that, which means it's reliable. So if I were going to play him, I actually, in my mind, I think he's a cross between Jeremy Piven's and Dan Lovitz. But I actually am going to put Joe Lo Truglio, just because he seems to fit. If I were doing this as a show, he would be the guy that does the discovery, goes after documents, and he just loves that part of the job. And anyway, I don't know if that's what's going to happen, but I just like Joe Lo Truglio being in there. And also, I love the movie Pitch Perfect, so I'm trying to bring in people from Pitch Perfect. And he was what was the name of it? Tone Hanger, one of the a cappella groups. Okay, next attorney. This is the last attorney for Disney. This is a Florida attorney, Adam Losey. He has his own firm, I believe, with his wife. So he's a partner there at that firm, went to law school at Florida College of Law. And then he represented the state of Florida in a big case called the Water Wars litigation against Georgia. It was ultimately, the gist of that case was that they were saying Georgia was using too much water, or doing something with the water that was causing the oysters in Florida to struggle. So ultimately, Florida lost that case. Georgia prevailed, but he was an attorney working on that case. And on his website, he says he works for mostly Fortune 500 companies and owners and things of that nature. And so I think he looks like Will Arnett. He gives me that vibe. So I put Will Arnett as his actor. But if I were making a show or something, I would want to maybe have someone else, a woman in there. And so I'm going to say Anna Camp to bring in another Pitch Perfect. I'll say Buddy. So Anna Camp, and the gist of this would be, she's like fresh out of law school and wanting to make a name for herself. She's from Florida and comes to this firm in this big firm that's O'Melveny, and she wants to learn, and all of a sudden they get kind of dumped on this Florida case. So she's roped into it because she's, the licensed attorney there in Florida. And so it's her just getting her feet wet on this big giant case. And anyway, that's kind of, I don't write movies, but that's kind of where I'm going with this one. So anyway, that's the Disney team. And now let's go to the board's attorneys. The first one is Charles or Chuck Cooper with Cooper and Kirk out of DC. He's the founding partner of that firm. He's from the South. He went to the University of Alabama. And back in 2013-ish, around that time, maybe, and my dates could be off. But anyway, he was the lead. It must have been, anyway, early 2010s. He was the lead attorney in the case supporting the California gay marriage ban, or Prop 8. And I remember that because I went to BYU law school, and he came and did a lecture, a presentation on the arguments for Prop 8, which I don't remember exactly what he said, but it was interesting. And I came away thinking, I don't know how good of a job he did. Don't remember the details, but when I was looking up this case, I was like, man, I feel like I remember that name, and he looks familiar, and that's what it's from. He did a presentation when I was in school, but obviously he lost that case. He also was involved in the in the Gore-Bush litigation. He was on the side for Bush, which did win. And then he's been in a bunch in the Supreme Court and a bunch of other constitutional cases. I think a couple First Amendment cases too, like this one is. So that's Chuck Cooper. If I was putting in casting a celebrity for him, Dennis Quaid. Think a very similar vibe. Next attorney is David Thompson, managing partner at Cooper and Kirk. He went to law school at Harvard. He's been involved in a bunch of legal matters that were in the news. A while ago, there was a Duke lacrosse team that was they were all accused of rape, and it was a really botched prosecution. The prosecutor ended up being disbarred and actually sent to jail for, I don't know if it was falsifying evidence or just not disclosing evidence that would have helped the Duke defendants. But anyway, they ended up suing Duke and the city, and David Thompson was their attorney. And the news says it was three of them, that they made $20 million each. He said that was overstated in the news, but anyway, he was the attorney for that. The torture memos during the Bush administration, he was involved in that issue. And then he's been involved in the 2020 election, I'm going to say debacle. He filed a bunch of litigation dealing with that. So he's been in the news plenty, taken a lot of high profile cases. That's David Thompson. And for him, I feel a little bit conflicted because I want to, if I bring in more Pitch Perfect people, I would bring in Ben Platt to play David Thompson. But my first impression, if I'm not trying to bring in Pitch Perfect people, which I don't know why I am anyway, but my first impression would be Damian Lewis from Band of Brothers. Is where I get him from, but it seems like he's got a good demeanor for him. Okay, next attorney is Peter Patterson, also with Cooper and Kirk. He's a partner there, went to Stanford Law. And honestly, I couldn't find all that much about him other than he's a contributor to the Federalist Society. And then he helped David Thompson in filing and pursuing the voter suppression lawsuits for Trump, which obviously didn't go anywhere. But other than that, I don't know much about him. And I would put Adam Levine. And I guess my thought in here too is if this were a series or something, you'd have the Anna Camp for the Team Disney, and then Adam Levine, Devine, getting those people mixed up. Anyway, maybe there's some sort of a love interest there or connection, even though they're on opposing sides of litigation. I don't know where I'm going with that. Yeah, but I covered him. Next attorney, this is the first female on the board's side, Megan Wold. She is also a partner at Cooper and Kirk, went to Notre Dame Law School. She also clerked at the U.S. Supreme Court, I believe for, I'm just guessing, but I think it was Justice Alito, and I could be wrong on that. But one thing she did was she assisted in drafting Idaho State's anti-abortion bill. She did it as a lobbyist for Right to Life Idaho. So she is very conservative politically. And on their website it says that she focuses on complex brief writing. So I kind of imagine her as being the person that's writing a lot of the briefing for the various issues, perhaps including the motion asking the judge to rescind himself, which I'm going over next. So I would have another Pitch Perfect alum here, played Stacy, Alexis Knapp. She would be Megan Wold. And then in my version of the story, I'm thinking, maybe Megan Wold is actually a Cooper. And so she's like the daughter or granddaughter or something of Chuck Cooper. And then David Thompson is supposed to be taking over the firm. In his mind, he just worked hard, but then she comes in and kind of messes it up for him, or there's some drama there. I don't know, but the idea is she is Stacy in Pitch Perfect is she's kind of a dummy, but in this she would not be a dummy. She'd be very good. Okay, and then now we have the Florida attorneys here. Just as kind of some background, anytime you're practicing in a court in a state or in a state at all, you have to have permission to be there by the bar or by the court, or I guess technically both. And so that's called, if you're not licensed in Florida, you can be admitted pro hoc vice, which means friend of the court. No, that's not what pro hoc vice means. That's I don't remember what pro hoc vice is because I don't speak Latin. But the point is, you come in and ask the court to be there temporarily for a specific case. And so most of these attorneys are appearing with the intent to file a pro hoc vice motion before they do any oral arguments or things of that nature. But in the meantime, you have to have a local person to be able to look over your documents, make sure that they comply with the local court rules, and just be responsible for you. And so Adam Losey is that for the Disney side, and Alan Lawson and his partners are the local attorneys for the board. And so Alan Lawson, there are actually 3 partners listed, but he's the one that signs everything. Lawson, Huck, and Gonzalez are all partners listed in the litigation. He's a shareholder, Florida State University. He's a former Florida Supreme Court judge and actually was a judge in the Florida Ninth Circuit, which is where the board's lawsuit was filed against Disney. So he was in that district or circuit. And then when we're talking about the contracts being voided, there was a presentation for the board as they were making that decision, which they were going to do anyway, but there was a presentation, and Mr. Lawson was the person that was giving the presentation regarding the problems with the Florida, with Disney not complying with Florida parts of the law. David Thompson was also there. He spoke more about general breach of contract or contract principles. Lawson spoke specifically on the Florida thing. So it's not that he's just there to rubber stamp things and check on procedural things in Florida. He's participating in the litigation. And I think, he's going to be an important person for their team. But I'm not listing the other partners. So he gets to be he gets to represent all of them. And since I'm combining all of them, the celebrity I'd have play him is Morgan Freeman, and he kind of stand for all of them. I'm picking him because seems like he'd be a good former judge. Maybe he's a little bit tired of legal mumbo jumbo and just wants decisions made, and also I'm thinking he might be a little bit thinking, hey, I'm a former Florida Supreme Court judge, and I want to have a little bit more say in this litigation. I don't want to just be left in the back burners and all that. So anyway, that's Alan Lawson. And that does it for the board, the Central Florida Tourism Oversight District attorneys. So now we're moving on to DeSantis' attorneys. He's, of course, represented by the Attorney General's office. And the Attorney General of Florida is Ashley Moody. She went to Stetson University for law school. She was a prior U.S. attorney, and also she was a Florida judge. And as the Attorney General, she's taken conservative stances on a lot of issues. She sought to repeal the Affordable Care Act. And then Florida was a supporter of the 2020 election lawsuits that, again, just kind of all fizzled out. So that's her. She became Attorney General in 2019, at the same time that DeSantis became governor, right? I think that's right. And then the person's actually, so the person I'd have play her is Kether Donahue, and she's a pitch perfect actress. She played the former head of the Bellas at the very beginning, named Alice. So maybe I'll play a clip from that just so you can see where she was, or what her tone is, because that's kind of what I've imagined for Moody.
Chloe, look at you. You're a mess. You're unfocused. You're unreliable. And your breath smells like egg. Like all the time. I can't believe the ballads are being passed on to you two slutbags after we graduate. Just don't F up your solo.
I won't disappoint you. My dad always says, if you're not here to win, get the hell out of Kuwait.
Has your dad ever told you to shut up?
Okay, then the person that's actually signing the pleadings for the Attorney General's office is John Gard. He's the chief deputy attorney with the AG's office there. Law school is Tulane University. He was a federal prosecutor and a partner at a private civil litigation firm. And the news said that his appointment was viewed as non-political. So, kind of a neutral selection. Strikes me maybe he's just a guy that wants to do good work regardless of who it's for. Not sure exactly what that means, but yeah, he's the one that put his name on all the court filings so far in the litigation. And I didn't really pick an actor for him. Maybe I'd do Josh Gad, just off the top of my head here. But I feel like there's so many attorneys on this side, it's hard to pick them all, but yeah, maybe Josh Gad. Okay, now that covers the attorneys, so on to the actual judges. There's 2 federal court judge, state court judge. Mark Walker is a federal court judge with the U.S. District Court for the Northern District of Florida. He's the chief judge there, which means he just has some management duties. He went to law school at the University of Florida, and in the news it kind of reports that he's known for his unique style and humor. I have a picture of him here with a bright blue bow tie on. And he also is known for making pop culture references in court, even spontaneously. And then DeSantis has commented that that Mark Walker has ruled against him a bunch. So he was kind of frustrated that Disney's going to this guy. He's like, oh, of course it's going to rule against me. It's a stacked court. But in this case, this is the judge that DeSantis is asking to recuse himself, kind of because, in some ways, of his propensity to make pop culture references. And I'm going to get into that next, but he made some comments about Disney, which DeSantis says shows that he is biased in unrelated cases. Okay, so that's the federal court judge, state court judge. Oh, yeah, so the guy I have playing him is Chris, I'm blanking his name, Holter. I don't know why I can't remember his name. Dr. Spaceman. That's how I know him. But anyway, I thought he looks exactly like him. Actually, the first person that came to my mind was the principal from Billy Madison.
Mr. Madison, what you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it. I award you no points, and may God have mercy on your soul.
If not him, Dr. Spaceman. State court judge is Margaret Schreiber. She's over the Florida 9th District. She's the administrative circuit judge, which again means she just has some management responsibilities within the court there. She went to law school at Vanderbilt. And I'm going to play an interesting clip here of her. She did a presentation, or they would do a podcast, the Ninth Circuit Court, just to help people get to know the judges. And so she was on that, and I'm going to just play this because it just kind of interestingly ties somewhat into this case.
I was very involved in the music program
is it playing?
in high school, and was actually the accompanist for the choral groups. So we did a bit of touring. One of the tours was to visit a new development or attraction that had just opened up, known as Walt Disney World in Orlando, Florida. So I have one of the original old paper admission tickets from Walt Disney World that I've never used, and I'm curious to find out if it would still work.
So that doesn't have anything to do with anything other than this interesting. I mean, probably a lot of people in Florida have some sort of experience with Disney World. She has one. She still has the original ticket. So, I mean, clearly she has some sort of fondness for Disney World. But anyway, during her career, she was a second woman partner at her firm, kind of broke some ground there. She did stop practicing law for a little while, at least in private practice, and helped run a family construction business. So she was the general counsel there in addition to having some management role. But during the 2008 housing crisis and economic downturn, that business kind of died out or got slow enough where she decided to go back into law. And from there, she was appointed by Governor Rick Scott of Florida in 2011 to be a judge. And she's made her way over to being the judge in this case. So there you have it. That's the attorneys. And then she would be played by Sarah Jessica Parker. Anyway, so that is the attorneys for Team Disney, for the board, for DeSantis, and then you have the judges there. So that's kind of who we're dealing with. You maybe can get a feel for what I think their personas and personalities might be based on who I've cast. If you have someone different, let me know in the comments. And I don't really know what the show would be about, other than I'm hoping it would be interesting. Okay, so with that, let's go on to the next topic. I'm going to go over the board's and / DeSantis's motion to have Judge Walker recuse himself. Okay, here we go. I've got Ron DeSantis's, all the defendants' motion to disqualify Chief Judge Mark Walker. This is in the federal court, so I'm just going to go through this here. So defendants move to disqualify Chief Judge Mark Walker under 28 U.S.C. Section 455A because the court's impartiality in this matter might reasonably be questioned. This case involves claims that defendants retaliated against Walt Disney Parks and Resorts based on Disney's viewpoints. Yet 2 previous times, in 2 unrelated cases, the court sua sponte, which means on its own without prompting by another party, offered Disney as an example of state retaliation. Those remarks, each derived from extrajudicial sources, the news, were on the record in open court and could reasonably imply that the court has prejudged the retaliation question here. Because that question is now before this court, and because that question involves highly publicized matters of great interest to Florida citizens, the court should disqualify itself to prevent even the appearance of impropriety. And I actually like how the attorneys approach this, because they're not coming at the judge and saying, "You're biased and we know it." They're saying, "You made these remarks. It even if it just appears that you might have a bias, and we're not saying that you do, we're just saying that it appears to be such, then the appropriate thing to do under the statute, which will be addressed, is to let another judge take over." So now they're going to get into the 2 instances they're talking about where the judge commented about Disney. First case is Link versus Corcoran. And the plaintiffs said that state education officials would punish them, the plaintiffs, for the results of their intellectual freedom and viewpoint diversity surveys. This is an education case. The plaintiffs argued that government reprisal is not a speculative risk because Governor DeSantis and Commissioner Corcoran have practically promised retaliation against plaintiffs' speech. And so then the court's going to get into, well, I don't know if this is speculative or there's specific threats, because in order for me to grant an injunction preventing them from doing something, we have to it has to be specific. It can't just be speculative. It has to be for sure. So the court says, I don't understand how, it seems to me how you can say that threat, the chill or the chilling of your speech, is reasonable when you've got to assume so many things. They go on, and the judge talks about in the UF professor case, University of Florida, the chill, they knew who they were targeting, and they could target individuals, and so there was, and had announced their intent to do so. So they were attacking specific people in specific ways. So the judge is asking, what's in your record here, plaintiffs? For example, is there anything in the record that says we're now going to take away Disney's special status because they're woke? Something of that nature. So there's his comment about Disney. He's saying, give me some specific examples of the government going after you. What are they doing? He used Disney as an example of retaliatory act. So again, what's in the record that shows these very people have taken punitive measures against those they've described as woke in other contexts? Give me something here. So the court is saying, or not the court, sorry, the defendant's attorneys are saying, you've already concluded here that Disney was already a victim of government retaliation, because you're saying it could be an example of retaliation. In other words, this is how you obviously prejudged this case that's now before you. So the second case, Falls versus DeSantis. Now this is, and just the timing wise, I should mention that last case, this was just before, this case was going on just as they were announcing that they were going to do something about Disney. So nothing had actually been done yet. This next case comes somewhat similar. Well, let's see, am I mixing that up? I think it was just talk of that. Maybe I'm mixing that up, but this other one, on the same day that SB 4C became law. So the SB 4C, again, was the law that said that they would be dissolving the Reedy Creek District. That was followed by HB 9B, which said they weren't dissolving it, they were reconstituting it. So that's where we are in the timeline here. Falls versus DeSantis, there was a preliminary injunction on the argument that the state level defendants would take enforcement action against the plaintiff's schools if the plaintiffs expressed opinions that violated the Individual Freedom Act, thus chilling their speech. So if we say something you don't like, you can take recourse against us. The court summarized the plaintiff's theory that their speech was chilled because the defendants can, or so the state can, under existing regulations, cut funding, and if your school is going to lose funding, then it would certainly create a chilling effect on a professor who doesn't want to be the source or cause of his school losing revenue. So that's the specific threat that the judge was looking for in the other case. I mean, similar to. So then they have a discussion with the defense. So this is a discussion with the state's attorneys where, again, they're talking about threats and the fact that the government can retaliate. And so the court says, and then Disney is going to lose its status because, arguably, because they made a statement that ran afoul of state policy of the controlling party. At what point do you stack so many examples where punitive actions are taken if you don't do what you're told that suddenly it no longer becomes conjectural and you pass that threshold so you can establish standing? It's no longer fanciful or conjecture. So the DeSantis argument is here that the court cited Disney losing its status as among a pattern of punitive actions, suggesting that other future retaliation might not be speculative. So those are the two examples of cases where they're saying that Judge Walker has already found that the state's conduct against Disney was retaliatory and punitive. So he's prejudged the case. So based on the fact that he's prejudged the lawsuit, they're not going to get a fair shake, and so the judge should recuse himself and allow a different judge to take over. So let's go over the legal standard here. The statute that they quoted, 28 U.S.C. section 455A, says a federal judge shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. And in the law, there's a big difference between shall and may. Shall is mandatory, may is discretionary. So what they're going to say is this standard is mandatory disqualification. And so the only thing we're wondering, or that we need to look at, is can the impartiality of the judge be reasonably questioned? So the standard is whether an objective, fully informed lay observer would entertain significant doubt about the judge's impartiality. So it's kind of, in the law, we talk about a reasonable person standard. It's just like, what do you think a reasonable person would do? And sometimes that's totally fake. For example, I used to represent a lot of lower income people in cases, and the court would say, if you get served a lawsuit, a reasonable person would go hire an attorney and figure it out. It's like, well, these people don't have money to hire an attorney. Obviously, they're not going to do that. And it's very reasonable that you don't know what to do with these things. So you set it aside and hope that nothing bad happens. But anyway, then you go into court and ask the court to give them a chance. And they say, no, a reasonable person wouldn't have acted the way they did. It's like, that's what everyone does. Anyway, so the reasonable person is a little bit of a myth. It's like, how do we want people to act? And so anyway, when we say a fully informed lay observer, that's very squishy. The touchstone for recusal under section 455A is not the reality of bias or prejudice, but its appearance. So the very purpose of 455A is to promote confidence in the judiciary by avoiding even the appearance of impropriety whenever possible. Supreme Court. So I'm going to say. So anyway, their argument again has already been summarized. It's that, hey, judge, you've already made a decision here. And they cite a case that I think is important as an example called Franklin. In Franklin, a trial judge had referred to Franklin, a defendant, who was alleged of committing additional crimes while released on bail, as an example for why a different defendant should not be released on bail. So the point in that case was that this Franklin defendant, it seemed like the judge had already determined that he'd committed an additional crime after being released on bail, even though he was only he had alleged to have done that crime. So the judge was mandatory for him to recuse himself based on the fact that it looked like he had already determined that this defendant was guilty of a subsequent crime. So in context, despite the judge's use of the magic words alleged, because Mark Walker said allegedly in the Disney quote, let me just go back to it. Oh, he used arguably. Disney is going to lose its status because, arguably, because they made a statement that ran afoul of DeSantis. So they're saying, even though you said arguably, it doesn't matter. Alleged. The inference is irresistible that the judge was pointing to Franklin as a latest such incorrigible criminal, even though Franklin's trial had not yet taken place. This is powerful circumstantial evidence that the judge had prejudged Franklin's case, and that was the appeal court. So they're saying this is the same type of thing. This is it's obvious that Walker has already determined in his mind that Disney was the victim of wrongful retaliatory conduct by DeSantis and his government. And they say a good judge should engage in self-reflection in determining whether to remain on a case. The court's prior statements at least raise a substantial question about whether the court will resolve this matter fairly. And I think it's a really good move by DeSantis' attorneys because, number one, it might actually work. I mean, I think it's a really good argument if I were the judge. And I've had judges recuse themselves before. Like, for example, I was in a case and a judge, I just went to church with him and he disclosed that we went to church together. And the other attorney, the other attorney said, "Hey, I don't have a problem with that. It's fine. I'm sure you'll be fair." But the judge decided that he was going to recuse himself anyway, just because he didn't want the case to go bad, or the case, he didn't want to rule in my favor, and then the other attorney would end up deciding, hey, it is just because they're church buddies. So I don't think the standard is that high for judges to say, yeah, maybe I should recuse myself. And like they quoted, a good judge would say, look at it objectively and say, yeah, maybe I did prejudge here and I should let another judge take over. So I wouldn't be surprised if that happened. At the same time, if the judge decides, no, I'm gonna stay in the case, and then he rules against DeSantis, it's just a way that DeSantis could get, hey, look, we knew this was going to be the outcome from the very beginning. This was a stacked court, biased judge. He displayed his bias already. No wonder he ruled against us. And so it's just a way for, if Judge Walker does end up ruling in favor of Disney, that you're going to have some public outcry and say this was all rigged from the beginning. It wasn't a fair trial. And so in some ways, if I were Disney, I might say, yeah, I guess maybe I would be fine with another judge stepping in. But at the same time, maybe you don't want that to happen because you think Walker's going to rule in your favor. Anyway, so it just raises a really good issue. Very curious to see how Disney responds. Maybe even the judge will make a decision without having a response. So I'm going to be monitoring the docket, and we'll see what happens here. But regardless, I do think you got to question, why are there so many cases where people are going into the court asking about DeSantis's government attacking him for exercising their speech? I mean, this is at least two where he talked about Disney, and then we're on our third, which is the Disney case. So how many of these are going on? That's a question I do have. Okay, one more thing I just wanted to add on this judge issue. So let's say you want to have a judge that's of your same political ideology. So if I'm going to the Northern District's Court of Florida, there's 8 judges, 1, 2, 3, 4, 5, 6, 7, 8 district judges. And if I pull them all up, the first one is Walker. He was nominated by Obama. So we'll just go through them here. There's a Ronald Reagan nomination, Clinton, Obama, Bush, Trump, Oh, Gerald Ford. And Bush. So if I'm DeSantis, I'm thinking the odds of me getting an attorney or a judge that might be more conservative minded is pretty good if you can get Walker off the case. So that might be something else they're doing. A lot of things going into play. Just thought that was an interesting point. Hey, if you thought this video was at all interesting, or if you want to see what happens next, please like and subscribe. It'd help me out a lot. Thanks.